Okay, so we are now streaming on YouTube, Facebook, and on our website.
All right. Well, good morning, everyone. We are so excited to have you all here with us, joining in as we have a discussion surrounding Central Ohio Reentry Week from a judicial perspective. All of the judges who are joining us on the panel have jurisdiction over adults. There was a panel earlier this week from juvenile judges. My name is Lasheyl Stroud. I'm the moderator for this session. I am a judge in domestic relations in juvenile court, and really just here for us to have a conversation and hear from these judges, from their individual perspectives about what reentry means to them and more about their judicial philosophies surrounding this topic. So I am so excited to be here with all of you on this morning. I believe we have 2 additional judges who will be joining us shortly. As you all know, judges have some obligations in the courtroom, and I'm sure those 2 judges will be with us any minute. So we'll go ahead and get started to not cause any further delay. We'll be together for 90 minutes this morning. And like I said, just really interested in having a discussion and conversation so that you all can hear more about what reentry means from the judicial lens. So as we start, I'll first go around. The request was that we have an informal session. So in lieu of reading bios, I'm going to have each judge share about himself or herself, a little bit about their background and what led him or her to the bench. So we'll get started first with Judge Sargus.
Well, good morning to everyone. I'm delighted to be with such a distinguished group of judges, most of whom I've known for a long time. I'm a judge in the Federal District Court for the Southern District of Ohio. I sit in Columbus, but we cover 48 counties. And we do exclusively felony cases. So we have a focus on things involving drugs, oftentimes addiction and mental health. So it doesn't take long to be in this job to realize that to be effective, to make the community safe, but also to give offenders the chance to be what they can be, that we need to worry about reentry. So the last 10 years, I've had the pleasure of putting together with other judges on the court in our probation office, a reentry program that focuses on people returning from federal prison, trying to help them weave themselves back into the community and handling all sorts of things such as reemployment, medical care, addiction services, all the different things that are necessary for someone to succeed after having some problems. So one of the most rewarding experiences for me in the 25 years I've been a judge is to be able to see people succeed after having had a brush with the criminal justice system. So I can't think of anything more gratifying that I've done as a judge than to be part of this. Just briefly, I was the U.S. attorney in the district before becoming a judge. And before that, I practiced law for 15 years in the small but great town of St. Clairsville, Ohio. So one of those jobs as a young lawyer where you know your community and all the problems and you see the suffering up front and personal, which I carry with me. And I think that's been a big help in looking at people struggling in the criminal system as well. So I'm glad to be here.
Thank you, Judge Sargus. If we could hear from Judge Reece next.
Sorry about that, on mute. My name is Guy Reece, and I am a retired judge. I served on the Common Pleas Court in Franklin County for over 20 years. Currently sitting by assignment, and today I was on the road. I'm down in Hamilton County today, sitting by assignment from the Supreme Court. My background is I basically tell folks I'm just a poor country boy that had an opportunity to do something different. One of 9 children, first to attend college, certainly the first to attend professional school. Became a lawyer because of experience in the military. I did over 30 years in the military, reserve and active. In the military, I had an opportunity to serve as a trial counsel, and then that got me interested in the law, and became a judge because I felt it was important to serve the community. And I considered serving as a judge an opportunity to do more than just practice law, but also to be a servant for the community. I look forward to participating in this because I think it's very important to not only for judges to look at what occurs in the courtroom, but it's critically important that we be involved in what's going on outside of the courtroom. First, as an example, and also as one trying to enable people to be successful. And I look forward to this opportunity.
Judge McIntosh.
Thank you, and good morning, everyone. I currently serve on the Franklin County Court of Common Pleas General Division, and I've been on the General Division since January of 2007. When I got out of law school, I started as an assistant prosecutor in the city attorney's office and did that for a couple of years, and then had an opportunity to work at the Secretary of State's office when Sheryl Brown was the Secretary of State. Then had some time working at a firm, Crabb, Brown, Jones, Potts and Schmidt. Got some civil litigation, but also did some criminal defense work as well. And then was provided an opportunity to become the chief prosecutor for the city of Columbus. I did that for approximately 10 years prior to getting on the bench. One of the reasons that I decided to run for judge, because I had reached a point in my career where I thought that I could hopefully make a difference in that capacity, having had a chance to work as a litigator in front of judges for over 20 years prior to that. I just kind of felt that it was a time and an opportunity that I could bring my skills to the bench and hopefully be able to do more as it was with respect to the judicial system.
Thank you. Judge Mingo.
Good afternoon. I am Judge Stephanie Mingo, Franklin County's environmental court judge here in municipal court. And actually, prior to coming to the bench, I started my career as a guardian ad litem in Franklin County's Juvenile and Domestic Relations Court. I decided after being in private practice for several years, I decided I want to take a little time and have my own children. So I left private practice and spent some time having babies. And after that, I decided to get back into the public practice of law. So I went to work as an assistant attorney for the Ohio Auditor of State. I spent some time there, and then after leaving there, I again decided I'd like to have another child. So it took a little bit of time to have my second child, and then I found myself as a county prosecutor for Franklin County. And really, I guess what brought me to the bench is time and chance. In working for the county prosecutor, I was assigned to the docket in the environmental court, and the seat in environmental court became open after Judge Dan Hawkins won a seat in Franklin County Common Pleas Court. So I was fortunate enough to be appointed to complete that term, and I find myself here now in my third year. My third year on the bench. And it's a special seat. It's a very different court. The work here is a little different than the other 14 courtrooms in Franklin County Municipal Court. A lot of folks think of the environmental court as Franklin County's housing court, when in actuality, we actually don't hear landlord-tenant disputes or anything like that. We really focus on properties within Franklin County that are considered to be a public nuisance. So it's a special court. It's very different. I'm so honored to have a seat on this bench. I'm really excited to be here today. I want to echo what Judge Reece said. I think it's so important for judges to actually go beyond the bench. We spend so much time talking in the courtroom, but we don't always have the opportunity to do a lot of listening within the community. So I think it's so important for judges to go beyond the bench and make important contributions in that regard. So Happy to be here today, Judge Stroud.
Thank you. And last but not least, Judge Munson.
Hello, good afternoon, everybody. I am new to the bench. In fact, had the pleasure of running alongside Judge Stroud this past cycle, and she is very dear to me, so I want to say hi to her. I took the bench in December of 20. Prior to that, I had been with the Franklin County Public Defender's Office for almost 27 years. I was originally born and raised in Marion, Ohio. I was also first generation college student. My father struggled with addiction, and ultimately we lost him to suicide. And so I think that when I went to law school, I always kind of carried that with me. And I had some mentors in law school that kind of directed me towards the public defender's office, because I really wanted to serve people out of the belief that everybody deserves to have at least one person that cares about what happens to them. Everybody deserves to have somebody that will stand beside them in their darkest moment. And it was very fulfilling to me to be that person, or at least to attempt to the best of my ability to be that person. And of course, as a public defender, you know, we serve a special population. We serve them, you know, as legal counsel, but also there's so many other things and needs that have to be met to even get them to the courtroom. You know, addiction and mental health and transportation and housing, and food scarcity and childcare and all of these things that, you know, you were trying to wrap around your client just to bring them to a point where they could be on equal footing with people coming from other neighborhoods and other places. And so ultimately, that's why I ran for the bench. There was not currently on the Common Pleas bench a former public defender. I felt that was a place that could be filled. Somebody with my perspective, you know, serving the underserved, because we see so many of those on both sides in criminal cases and even parties in civil cases. And of course, I was fortunate enough to practice in Common Pleas Court for about 22 years. And I was honored to practice in front of both Judge Reece and still in Judge McIntosh, who incredible role models for the kind of work that I wanted to do, which was compassionate and meaningful service. And so I owe a lot of my desire to run to having had those sorts of role models that told me that this job could be done with compassion and done to meet the needs of everybody. And so that's why I ran, and I was so fortunate to win, and I'm honored to be serving everybody in Franklin County at this time. So thank you also for having me.
Well, thank you all. Thank you to all of our panelists for your introductions, to let everyone who's viewing get to hear more from you about who you are and what led you here to the bench. To all of our viewers on YouTube, Facebook, and whichever channel that you're watching us on, I would like to encourage you to ask any questions that you may have, and the host will let me know what those questions are, so that hopefully we can incorporate that into our discussion. Welcome to those of you who are just joining us. We are about to have a discussion from the judicial lens about reentry and what it means to us as judges. What we're hoping is that this will be more of a conversation, a discussion. I have received some questions in advance, and we won't go around and just have all of the judges answer each question. I would love for the judges to just jump in if there's a question that you feel that you would like to share your response. And then there's some that I will ask specific judges about, and others, again, can feel free to jump in. The request was that this could be an opportunity for the viewers, again, to hear from us, not just as judges, but as people. One of my mentors told me, you know, when I came to the bench, that being a judge is what you do, not necessarily who you are. And at times, I believe sometimes people start to see us solely as this position. You know, the judge, the person who has the final say in the courtroom. But the goal for this discussion was for people to really hear your heart, which is why I believe this is a great group of panelists to be able to share your heart and the why behind what you do. as well as your passion for reentry, and why that is so crucial and critical to the roles that we all perform. So the first question that I'm going to ask is, what is your judicial philosophy? And if you would, in that response, incorporate a case that has shaped or changed or expanded your judicial philosophy. I'll start first with Judge Sargus, and then go to Judge Reece, and any other judge that would like to jump in, feel free to do so.
Thank you, Judge Stroud. That's a great question. I don't mean to be cantankerous, but I try not to be too philosophical about this. So I don't have a philosophy to start with. We have a case in front of us. We have a person. We have a story. We have somebody's child. And we also have the public. So there are a lot of interests when you have a criminal case. I'll go back to where I started. If we can help a person get through addiction, get past some mental health problems, get better employment, get health insurance, we've made that person better. We've made the community safer. There are many times we have to punish people, but I can't ignore that. Sometimes there are consequences that can't be undone. But I think the whole idea of restoring citizens is the idea that none of us are perfect. Some of us are born with addictions, mental health struggles, all the sorts of things that, in the way we've designed the system, bring you into contact with law enforcement and the courts. And this can be a place where it's almost like eternal damnation, where you come out, you're still psychotic as you went in, and it's just a matter of time until you have another breakdown. And it's the person who headed net care for years, King Stump, calls that wash, rinse, repeat. And we don't want that. We want to break that cycle. We want to be able to say we've made this problem a little better. It's hard work, doesn't always work, but it can in many cases if we just keep our nose to the grindstone. And as judges, we do what we can systemically to have people with the resources they need to succeed. You can't change somebody and make them succeed, but if they want to succeed, you can at least have the tools ready for them.
For me, my philosophy has always been, number one, treat everyone with respect. No matter who's coming into the courtroom, you need to respect them. The defendant, the plaintiff, the victim, the witnesses. The court deserves a certain amount of respect. I don't demand it for myself because if you're demanding it for yourself, then maybe you're focusing on the wrong thing and not focusing on what your job really is there. Treat everyone with respect and realize that even most of the people that come in front of us from a criminal perspective will eventually walk out. They will eventually walk out. And it's important that we look at the ability to, when they walk out, will they have an opportunity to be successful? Quite often, judges don't think that way. They think more of punishment. Punishment is appropriate, but also return is important also. And those folk that leave our community in a certain condition, if we don't do something to help them or benefit them, they're going to return to our community in the same way. And that's an opportunity that we need to take advantage of. And sometimes it involves doing it in the courtroom. Sometimes it involves doing it in the community. And we need to be adaptable when we try to do that.
If I may, one of the things that in practicing what I observed is that unfortunately in some of the courtrooms that you practice in, the goal is to try to get through the cases as quickly as you can, get through the docket as quickly as you can. So if I had a judicial philosophy when I got on the bench, it was that I was going to slow things down and give people that practice in front of me time to let me know who they are, let me understand the issues that they have, Despite the fact that it's common pleas court, a lot of the people that come before us, I view as people who have committed crimes as opposed to criminals. Their situations, their circumstances, many times put them in a position where they're doing something which they shouldn't be doing, that unfortunately gets them into the criminal justice system. And so getting on the bench, what I realized was the needs of so many of the people that come in front of me are so great. And while we do what we can to get them linked to the services that they need, so many of them are so far behind that there's only so much that the court can do. But we should be willing to give of our time and our resources while we have them to give them opportunities for success. The number of folks that appear before us without a high school degree, the number of folks that appear before us with no positive role models. They have role models out in the community, but they don't know, which is the sad part. They don't know what they need to do to improve their situation and circumstances, because the only folks that they follow are the ones that have sort of led them into the system. So I just think it's very important for us as judges to be willing to spend the time and try to figure out what the needs are and do as much as we can to help address those needs. And I like the point that Judge Mingo made, which is that, a judge is, you don't want to come across as, because I am the judge, I am somehow omnipotent. You want to let people know I am the judge, and yes, as Judge Reece indicated, yeah, there may be times I need to impose sanctions, but what I really want to do is provide you opportunities to do the sorts of things that you need while I have you, so that you don't have to come back to see me later. And so I think that's extremely important.
Absolutely, I agree with what all of you have said, and we'll also hear from Judge Munson and Judge Mingo if either of you would like to weigh in. One of the things that I was going to touch on from what the three of you have said, here in juvenile court, at least from the delinquency side, it's separating out, just like what we said earlier about ourselves. We're judges, but that's not who we are. As people, being a judge is what we do, but not who we are. It's the same thing that I tell the youth that come in front of me. There's a difference between what you did that led you here and who you are. And how can we in juvenile court, because our hope is that the youth that come before us don't have to come before any of you, that we can do what's necessary to rehabilitate them, provide them with the services while we have them here. So more so, what was the path that led you to come before us, and what can we do in hopes of rehabilitating you to keep you from returning here, and absolutely from returning, from going or entering the adult system. But I saw Judge Mingo unmute, and then Judge Munson. I'd love to hear from both of you as far as your judicial philosophy and what you feel has shaped it.
Thank you, Judge Stroud. I will sort of piggyback on what Judge Sargus said. I hate to lock myself into a judicial philosophy. I feel as though every case is unique. The set of circumstances that brought that case before me is unique, and I want to make sure that I listen with a fresh set of ears for each and every case that comes before me. And I want to add to something I said earlier, and I think it's something that I think all of the judges have sort of hinted at. It's so very important for us as judges to be good listeners. I have found just on my short time of being on the bench that I can learn so much about my cases and what's driving the cases that we see here in environmental court. If I just take the time to sit and listen. And it's difficult, I think, because as judges, we have that pressure on us. Everyone expects us to, say the magic words that are going to, put the case in perspective and sort of, satisfy all of the parties. And when in actuality, on most days, I just want to sit back and listen. I want to hear, what is it that drove you into environmental court? Most of my docket is a civil docket. I don't hear criminal cases in the same capacity as my colleagues in the general division. The bulk of the environmental court docket, it's civil in nature. And so for me, as a newer judge, it's really been a lesson in humility, in that it is so important that I not perceive myself, as Judge McIntosh said, as omnipotent. I don't have all of the answers, and I never will. But what I can do is actively listen to learn what drives these cases, listen to learn how I can help.
To weigh in before we move on?
Yeah, I'll just say, in terms of as calling it a judicial philosophy, I think more for me, it's sort of, just my philosophy sort of as a human being in terms of how I hope to approach the job. And certainly I echo 100% what Judge Reece was saying, that first of all, improving the circumstance of people and giving them tools to be better, I think is incumbent upon us as human beings. I think everybody has worth as a human being, no matter what they've done. No one should be defined by the worst thing that they've ever done. They have inherent value, first and foremost. But even to those that maybe that's not necessarily a convincing argument, as Judge Reece was saying, except for the most serious offenders, they're coming back into the community. They will be back among you. And how do you want them back among you? Do you want them improved and resourced in a better place? And I think across the board, that answer has to be yes. It's a benefit to society. And so primarily, it's really just my belief in the value of people and their worth. And I would also say, and I know Judge Mingo referenced this early on in terms of judges going beyond the bench. And I think that's critical too, for us to be out into the community and meeting people where they are. It's so probably easy for us to sit, in chambers or on the bench and have the people come to us. But if we're in the neighborhoods and again, we're servants, we are elected to serve. And so that's how I view myself, as a servant. And so I think to be in the community as much as possible, serving is also critical, so that you maintain your perspective, you maintain your humility, and you're meeting people where they are and understanding who they are when they're coming into your courtroom, so that you always, provide them the benefit of the doubt and knowing that they are human beings and they deserve to be treated as such, and they are worthy as such. And so I think that's kind of just more of my, personal philosophy, but hopefully that translates into how I do my job as a judge.
Absolutely. I love that. We are all servants first, which is why we're here, to serve our community, and also recognizing that at any point that we could be the people on the other side of the bench that are coming before us. So making sure that we have that humility and we take it to every case that we preside over. Judges, what do you like or appreciate most about the bench, the oath that you've taken, and the execution of your responsibilities? So what do you like or appreciate most?
Well, I'll go first. People ask me all the time about what it is that I like about the job. And my response is always, I actually have a job where every day I have an opportunity to make a difference in someone's life. And I don't know how many people have a job like that. But, as has been echoed here, there are real people coming in front of us every day with real issues and problems. And so having that opportunity, obviously I don't change someone's life every day, but at least having that opportunity makes it easier for me to come into work each and every day to hopefully do something, provide something that makes a difference for someone.
If I could second that. By the way, I've been on a lot of panels with Judge McIntosh over the years, and I usually wind up saying I agree with Judge McIntosh. That comment he just made is exactly right. I think every job has its pluses and minuses. This job has some minuses too, not many, but making a difference. And I've noticed over the years, I think that we have some people not as long in the tooth as I am, but when you've done this for a long time, I think you realize that sentencing is an art, and it's a human art. And the longer I've done it, the more I've tried to change how I've done it. But I think what I've tried to do more recently is to talk to the person I'm sentencing more than anybody else in the room. They're victims sometimes. We don't have as many victim crimes as my state court colleagues do. We have a lot more drug cases, for example, where somebody's also addicted. And there are times I have to give them a fairly harsh sentence under the law, under a mandatory statute. But I can still speak to them. I can still let them know I know who they are. I know some good about them. I know they have a future. Sort of what was mentioned by Judge Munson. There's humanity here. And we have to embody that as judges. I think that's part of the restorative process. If we want people, as Judge Reece said, who are coming back, we know that in almost every case, they're coming back. What can we do to make that a better person as he or she comes back? That's part of it.
Judge Sargus, you touched on, and if anyone else would like to respond to that, but you just touched on something which is also something we wanted to discuss, and that's really looking back in hindsight, now that you've been on the bench for as long as you have, if you were to look back at your younger self on the bench, what advice through this reentry lens would you have for your younger judicial self?
Sure, not to go into the minutiae of the federal system, but I mentioned we only do felonies, and the drug cases we do tend to be large quantity. They would not be diversion cases. They're not somebody using drugs. That's a very different sort of a situation. And when I first started, I always thought that's the distinction here. We do big time, high quantity drug cases. But what also happens, right now we have 900 people in Columbus under supervision of our probation office. Half of them are there for drug offenses, and many of them are going to have lifetime struggles with addiction. So you can imagine that many of them don't do well when they're drug tested every month. When I started, the matter of course was you're going back to federal prison, you relapsed. And it's hard now to look back on that and think, how was I part of that? Wow, where did that come from? We've changed that completely. You can wind up in prison eventually, but we're going to put you through drug treatment. We're going to send you to AA meetings. We're going to do a lot of other things. We have a probation office that's on fire these days. They're going to do everything possible to keep you from going back and making sure you have the tools you need. This Medicaid expansion a few years back has really opened up a lot of possibilities for treatment that wasn't there in the past. And I think there are just a lot more tools we can use. And in the greater Columbus area, there's so many additional programs we can access. And by the way, that's part of the judge's real challenge these days, is making sure you and your probation office know of the resources in the community. That shouldn't be hard, but it is. And we have to scratch at that all the time to know what's new and what's developed.
Judge Reece, what would you tell the younger Judge Reece now with all of your knowledge and sage wisdom?
Be careful. I don't know about that. One thing that I think is important for judges, especially new judges, don't get caught up in the title. Do not get caught up in the title. Realize that you have the ability to, I guess, learn more about the resources. If your question was, what would I tell my younger self? I would tell my younger self, learn about all of the resources that have been commented on, especially those that Judge Sargus just mentioned. And do not realize that hammer that you're using goes two ways. You may be hammering that person that's in front of you, but you're also hammering society, and I think society is realizing that incarceration is not the answer. And from a criminal perspective, we need to be using all of those things in the toolbox. Hopefully, I learned that over time. The other thing is, I go back to it, don't get caught up with that title. Remember that you are a person just like that person in front of you. And that's about it, I guess.
Judge McIntosh. Oh, Judge Munson, go ahead. What would you tell?
I'm still the new judge. I'm still the baby I'm there all the time because I'm new to the bench. But I guess really kind of just in reflecting forward is just that to evolve into a judge that I can be, look back and be proud of the things I've done is just really to be open-minded and willing to learn, willing to know when I don't know something, willing to reach out to the judges, on my bench, willing to reach out to dear former judges, Judge Reece, not that he's a former judge, but that he's not that he's sitting beside me here every day, but that I do get to see him and have those conversations with him, and Judge McIntosh and the rest of this bench who have all been so welcoming and open, to guide and to offer, and just be open to all of that, to knowing that I do not know everything, to acknowledge when I do not know something, and that it is critical for me to keep that open mind and be willing to learn and change and admit mistakes, so that I can, I'll ultimately look back on a judicial career that I can, be proud of. So that's kind of my forecasting of how I want to be.
Judge McIntosh, if you could share your thoughts on what you would tell through this reentry lens to the younger Judge McIntosh.
Well, I was very fortunate. I ran for judge in 2004. I was not successful. I ran again in 2006 and then was successful. And initially when I was running for judge, everyone said, okay, you got to be tough on crime. And I just didn't know what that meant. But it seemed like everyone thought that's what the community expectation was. And so I was fortunate because I think right around the time that I was elected to the bench, people began to understand that tough on crime was not a solution. And so our court, through Judge Bruner, started a drug court. And at the time, my understanding, it required a tremendous amount of effort to get buy-in from the judges, but they did ultimately. And so I think the philosophy of this court began to change more and more right around the time that I got on the bench, so that I was able to do a lot of the things that I had hoped to be able to do on the bench. So I've not had to change a whole lot, I don't think. I mean, maybe people that have practiced in fundamental, Ms. Munson, may have saw me draconian when I first got on the bench, but much nicer now, I don't know. Hopefully that was not the case. But I think it's been wonderful that the view of what should happen in the court system has changed and continue to evolve in a positive way during the time that I've been on the bench. So if I had a conversation with the younger me, it may have been, you needed to be a little bit more forceful in trying to do some of the things that you're doing now.
Mm-hmm. Judge Mingo, would you like to share any thoughts?
As I sit here listening to Judge Reece, Judge Sargus, and Judge McIntosh, it makes me think back to my days in law school. And I will be very honest, I thought judges were scary people. Not because, I was a law student and I was, inexperienced in the courtroom, but I just thought, I couldn't relate to the judges that I practiced in front of. I just thought, this is scary. I'm not sure, I'm not sure that I'm ever going to make it in this courtroom. I don't know, how to adapt standing before this individual. And so when I took the bench, I remember thinking every day I wanted to make sure that I never gave that impression. I wanted each and every individual that came into my courtroom to see the humanity, to see the compassion, and to see the kindness. And I also, I think as a new judge, and perhaps Judge Munson can relate to this, and certainly you, Judge Stroud, you certainly can relate to it. Franklin County, it's a tough town, right? We work so very hard to obtain the seats that we have. And I think as a newer judge, it would be so easy to get caught up into holding and clenching that robe very tightly. And I love what Judge Reece said, don't get caught up in the title. It is such an honor and a privilege every day to be able to take the bench and serve and do so with a servant's heart. And so I think as a newer judge, each and every day, it's sort of a challenge that I have to myself to take the bench and wear that robe very lightly. This seat does not belong to me. I was elected for a finite period of time to serve, and I will do that to the best of my ability and do it with a servant's heart. But I never want to clench this robe so desperately and so tightly that I lose sight of the purpose of why it is that I chose to serve in this capacity. I certainly want to remember each and every day that it really isn't about me, but it really is about the folks in Franklin County and making a difference to the people who come before us every day.
And all of you spoke about resources and your toolbox and knowing more about those things when you look back in hindsight. And Judge Reece, even when you mentioned the hammer, right, or the gavel, noticing that it can come back both ways. I often say, if the only thing that you have is a hammer, then at some point everything starts to look like a nail, right? So if you just come in and you're just beating, that's all you will see if that's all you're looking for. So I'm curious if we can expound for the viewers to know more about the resources, the toolbox. Some of you even spoke about specialty dockets such as, drug court. What shifts have you all witnessed from the judicial standpoint in the last decade? And if we can talk more about the sentencing aspect and the shift that you've witnessed, and just highlight for the viewers more about those resources and tools that you have available to you in your toolbox that perhaps you didn't have long ago.
Well, I'll jump in first if you don't mind. So on the federal side, when I started, the resources were quite limited. Prison or not prison. And that's generally not a good set of tools. You need so many more other things. And just as a starting point, there's a number of months I always have in the back of my head where, if you spend 3 days on a DUI in jail, you can probably keep your job. You can probably maintain your family. 3 years in prison, probably neither. Somewhere in between is the cutoff. And I always thought, wow, now technology's improved dramatically. I can literally give you house arrest and we'll know if you walk out your front door. That's not every case, but it's some cases. And then there are others where we can monitor everywhere you go to make sure you go to work, you go to the doctor, and you don't go anywhere else. And then the big explosion for us in the last 10 years is we've had access to the Albus House, which has a lot of possibilities for people who can maintain their job, see their family every day, but still feel the pinch. I do think sometimes people need a bit of, I tell people in court, I would like to see you skin your knee, not break your neck if we were riding on bicycles together. I want that skin knee to heal, and I want you to remember the accident, and you won't have the accident again, hopefully. So, with some people, if you've got a murder case, they're convicted, they're going to prison. We know that. But that's not the typical case I have. And we're always searching for different tools, different alternatives. Oftentimes it's inpatient treatment for some people that we never used to have the resources to fund. Now we do. So I think sentencing is a challenge. And there are people that fit one extreme or the other, but there are a lot of people in the middle, and we have to work hard to have the right alternatives for them.
Judge McIntosh, I know you only have a shorter period with us. If you'd like to weigh in on this.
I think, I mean, one of the I think better changes that have occurred is that we are getting more and more resources in the community. One of my frustrations when I first got on the bench was, particularly somebody with a drug problem. If I sentenced them today, it was probably, I don't know, 6-8 weeks if they were lucky before they got their assessment, and then maybe another month or two after the assessment before they could begin treatment. And so here's someone that I just sentenced that goes back to their community, and they haven't even had the opportunity to begin any sort of meaningful treatment. And the expectation is supposed to be that they're not going to use or potentially get back in trouble during that time. So we've been fortunate because of the number of resources that have improved over the last several years to be able to get them into treatment much quicker, which with so many of them is the key. Now, I am very, very fortunate because I'm our drug court judge. So the good thing about that is that people that are assigned to the drug court, I get to see them every week. So I really know, how well they're doing or how poorly they're doing in trying to battle their recovery. But it also allows us with our community partners to have, we can get someone into inpatient treatment much quicker. We can, utilize Mary Haven's women's program, the Amethyst program. We had one person yesterday in drug court. She's been in Amethyst for 2 years, but it's provided her structure that she's needed. It's provided her housing. And yes, she's had some bumps along the way, but she's continued to work hard at it and is going to be successful at some point in time. So what I really like is the fact that we have resources. And I think, well, this probably has happened to Judge Reece. I don't know if it's happened with Judge Sargus, and it probably will happen with Judge Munson. But I have had, parents call and ask if their child could get into a program, and I'm saying, okay, well, who are they in front of? Well, they have not been convicted of an offense yet, but if they don't get into treatment, they will. And so I think we need to work harder also to get people into treatment before they get into the system. Because yes, we have a lot of resources available once they get in, but it would be wonderful that if we could get them to what they needed before they found themselves having to steal or to break into a garage to get money to feed their habit.
Anyone else care to share about the resources of the toolbox?
I just want to a little bit piggyback on what Judge McIntosh was saying, because some of us, the common pleas judges, have had the benefit, and I've had it twice now, of having a presentation by in municipal court, what originally known as the MAT program is now it's becoming the March program, because it's actually expanding the availability of resources. But as the MAT stands for, medically assisted treatment, and so we know Vivitrol has made a huge difference with opiate and alcohol dependent people, because it's not a substitute as some of the former drugs were. It kept you off heroin, but you became addicted to Suboxone or whatever alternative was being used. And Vivitrol is different than that. And what they're doing, and they're offering us the availability of this program, is that they are meeting people at the jail, at the workhouse upon their release, and taking them downtown and administering that Vivitrol shot immediately, which what Judge McIntosh is saying is critical. That gap between if you're incarcerated and being released in relapse, that's a very small space. And so if you can fill that space meaningful way, which we're doing with Vivitrol, that makes a huge difference. And they are also over there. It is to Judge McIntosh's other point about people seeking help before they get into trouble. The program they're running over there on the 6th floor municipal court is a walk-in program, so that I could have somebody come into my courtroom who's not charged, or maybe it's a victim in a case, or somebody that's, a friend of the defendant, but you can see that this person's in distress, either a drug dependency issue or a housing issue or food scarcity issue. They are welcoming us to send people over to them on a walk-in basis. And so that bridge between that program over at municipal court and what it means for common pleas court is just another example of what Judge McIntosh is saying, and just the accessibility of resources and the timing of resources, which are just critical. And the other thing I would just say quickly is that we know now, that not only is mass incarceration not working, but incarceration in general has a huge impact. One day spent in the county jail is detrimental to a person in so many ways. So that if we can avoid incarceration or avoid stricter programming or lockdown facilities where low-level offenders are being mixed in with high-level offenders, we benefit them by not putting them in those environments and not training them up to be higher-level offenders. So those are the things. But I just really echo what Judge McIntosh said. The resource availability and the immediacy of it is really making a huge difference.
Absolutely. And we know the same even from the studies here in juvenile court. Just one night in what used to be called the detention center. Now we've changed the name to intervention center. But if a youth spends one night there, it decreases their chances of graduating from high school by 50%. Right. So there's so many things that we know that can happen. So we try to keep all of those things at the forefront of our minds when making these decisions. So I'm curious to know, what are you all's thoughts on judicial discretion and the importance of it when we're talking about on the criminal side, whether to hold someone or not when we're talking about pre-trial? What are you all's thoughts on discretion, and how do you view that through your judicial lens?
I guess I have the least, since I'm a retired VJ here. But I think with respect to releasing someone on pretrial should be within the discretion of the judge. You're supposed to get all of these factors in and look at them and then make a decision. I think one of the things that society needs to realize, and the judge, I'm not infallible. I'm not perfect. I didn't come here as a perfect being. There will be some mistakes and there will be some errors, but do not go in predisposed that everyone should stay locked up or everyone should be released. You have to listen to the case and make a decision as to what is appropriate for each individual that's appearing in front of you, realizing that you're probably going to wind up keeping some in that you should let out, and you're letting out a few maybe that you should have kept in. And when that bad thing occurs, where you've let a person out, realize that you acted on the facts that you had in front of you at the time, and you made the best decision that you could make, and be prepared to face the next person in front of you, because certainly there will be another person in front of you, and you do not want to take what you did with the person behind that person and apply it to them.
Yes, absolutely. Having a clean slate in between. For anyone who's viewing, who's not had an opportunity to observe or be a part of a sentencing day, if we're talking about general division in particular, which 3 of our 5 panelists are, those dispo or sentencing days, whichever you like to call it, is really just one case after another where the judge has reviewed the PSI, the pre-sentence investigation report, has all of the information and knowledge, and just coming in to every hearing, as that clean slate to hear from the attorneys, the parties, and the victims at that particular hearing. But those are scheduled, back to back. So that's what a dispo or sentencing day looks like in general division. So that is great to hear. Anyone else care to weigh in on this? What your thoughts are as far as judicial discretion, the role that it plays for you when we're talking about the pretrial stage?
Well, at the pretrial stage, and hopefully Judge Sargus weighs in as well, because I think they do better in federal court than we do in state court in making those sorts of decisions. When I first started practicing back in the 1980s, it was not unusual just to put a bond on, just because that's what prosecutors asked and what judges did. So we put a $3,000 surety bond, a $5,000 surety bond, and then you move on. And we've reached a point where it doesn't make sense to do that, because if you think the person only needs a $3,000 bond, then you just should release them on their recognizance. It makes no sense having someone sitting in jail with a low bond that keeps them in jail. And so slowly, we're moving in the right direction as it relates to bail reform, and understanding that we need to, yes, look at our risk assessment tools and make decisions about who stays in and who stays out. But I think also we need to make sure that we're just not putting on a bond but that's what we're used to, and we're not really looking at the person in front of us or the type of case that they have as to the reason why we're doing what we're doing. But I said that the federal court, I think, is doing a better job, because I think in federal court, it pretty much is we're either going to keep you in or we're going to let you out. And it's not any financial incentive keeping people in. And like I said, slowly, I think the state court is moving in that direction. And I think judges need to have discretion looking at risk. But I still know that we're keeping more people in than we should.
Yeah, I'll pick up. Judge McIntosh is right. Although I would call our system the good, the bad, and the ugly. The good is never use cash bonds. I've had one, I always have to mention, but that's because the defendant was very wealthy and offered it as surety. But he offered it, we didn't impose it. I've never imposed a cash bond. That's the good part. The bad part is that we detain a significant number of people before trial. There is a presumption of no release for a number of crimes, anything to do with a gun, anything to do with large quantities of drugs. There's a presumption that you are going to stay in custody. Cash bond doesn't figure into it at all. You can be released with all sorts of conditions, but our numbers have changed over the years, but probably 35 to 40% of our defendants are going to remain in custody pending final disposition of the charges. But bluntly, if Judge McIntosh, if you were using your discretion, you would detain a large number of those. I'm not sure you detain all of them, but they generally, I think I can say it is true. They're charged with some very significant offenses. They could either be a danger to the community or a risk of flight. Their potential sentence is so long that they might not stick around.
Judge Stroud, I was just going to say that, I certainly think we have to have a justice system that trusts its judges and allows judges discretion to produce fair and reasonable results. I think it's dangerous to have a system where judges have to move robotically. Mm-hmm. So I think it's important. Judicial discretion is important. I think it's difficult because of public perception, right? But something Judge Reece said is we are not infallible, and we will make mistakes, but we do our best and apply that discretion and do what we think is reasonable and wise, looking at every case with a fresh set of eyes, and do our best to make reasonable and fair decisions. So I think it's critical. I think it's a cornerstone of our judicial system, and I think we cannot lose that.
And Judge McIntosh, I know you need to leave shortly. Before you go, especially through your lens as the administrative judge in General Division, I'd like to hear from you before you go, your thoughts on how you are pushing the judiciary forward to an even more equitable place. And what you see your
Okay.
role in doing that.
Well, I think a couple of the judges have already mentioned how important it's for us to get involved in the community. And I think it's also very important for us to get involved in the legal community and sort of the decisions that are made. I think I always say one of the reasons that we have so many people in the system is that we have too many, we criminalize too much behavior. And for those of us that have been practicing for a significant period of time, the Ohio Criminal Code is probably, I don't know, Judge Reece, 8 to 10 times larger. I mean, we started with 1 volume. I think we have 5 now of criminal codes. So, I've been active with the Ohio Criminal Sentencing Commission, where we make recommendations to the legislature. Now, they very rarely listen to us, unfortunately, and trying, people always talk about, we need to reform the criminal justice system. We need to reform the criminal justice system at the same time that the legislature is continually adding more crimes to the system. So I think that's one way we as judges get involved. I've had the opportunity to co-chair a task force in looking at the death penalty in Ohio. Unfortunately, we were not tasked with whether or not we need the death penalty. That would have been a different discussion, but at least it gave us an opportunity as we tried. And again, the legislature hasn't gone along with many of the recommendations that we've made. But our goal was, okay, if Ohio's going to keep it, then let's make sure that it's only the worst of the worst that have to face that. At least I think the legislature now is taking up the recommendation we made as it relates to mental health and not sending someone to the death penalty that has a mental health issue. And we really worked hard trying not to send people or have people charged with death specs under felony murder. And that's, you're committing a felony and someone dies, and then all of a sudden now you're looking at the death penalty. And then I had the opportunity to work on a task force looking at the grand jury system in Ohio as well. And finally, some of the prosecutors around the state are taking up at least one of the recommendations which we made, which is that the local prosecutor should not be the one presenting the case to the grand jury in an officer-involved shooting. And at the time, we had talked with the Attorney General DeWine at the time, trying to encourage him to put a unit together. He was a little hesitant, I think, about doing it because the prosecutors were not that keen about it. But now, the AG's office actually now has a unit that will present and prosecute those cases as well. So I think we as judges have opportunities and voice because we see it every day that we need to do what we can to make the system more equitable because we know, as we're looking at the death penalty, the disproportionate number of people of color facing the death penalty. And so we need to make sure that we're doing the sorts of things to continue to make the system fairer. And then finally, right now, I am working with the Supreme Court. We have put together uniform sentencing entries, and we're working on hopefully getting all the judges around the state to use the entry. And this is something that the Chief Justice has been pushing quite a bit as well, because we're also trying to get some real statistics, some real numbers, so that we can understand what we as judges are doing. Who are we putting in the community? Who are we putting in prison? What types of sanctions are we imposing? And getting that data specifically so that we can, rather than sort of making anecdotal decisions, have the real numbers in front of us to see how the system is impacting people of color, and hopefully why in some situations. Because I always say, look, we cannot debate that the system impacts people of color more harshly than others. Now, we can debate the why, okay, and everybody has their reasons why, but we cannot debate the impact. It's clear that the system does. And so I've seen my role, hopefully just trying to work to make changes within the system that it can be fair for those folks coming in front of us.
Thank you very much.
Right. And I am going to slip off right now. Thank you very much.
Great to see you. Thank you.
Hi, Judge.
Good to see you as always, Judge.
Good.
Thank you very much for all of your efforts in those reforms, especially that sentencing database, so that we can have that transparency, both for the community as well as for ourselves as judicial officers, to be able to see the information that database will be able to provide us. So thank you very much. It's always a pleasure.
Oh, you're welcome. Likewise. Thank you, everybody. Have a good
Thank
week.
you.
Okay.
Thank you. You too. Judge Sargus, what about you? How are you personally pushing forward the judiciary to an even more equitable place? Judge Sargus.
You know, I'm sorry, you cut out or I cut out. I missed the questions. I'm
Okay,
sorry.
I was asking the same question that I just posed. How are you personally pushing the judiciary forward to an even more equitable place than it was when you first came?
Well, a lot of ways. First of all, we want our court and its personnel to look like the community. So that's always been a number one priority. We do have, as I'm sure all of the judges on this call have, we have a disproportionate number of people of color who come before us. And it's exactly what Judge McIntosh said. That is a fact. The why is another question. But I think one of the things that happens in the federal system that's so stark, and I'm sure the state court judges have examples that they can think of. But I was the U.S. attorney before I became a district judge. And the big job for the U.S. attorney is to prioritize what type of cases would be taken into federal prosecution. And this is an oversimplification, but there's a lot of truth to it. Judge Stroud, if you were the new U.S. attorney, you could decide there's so much healthcare fraud in Columbus. We've got Nationwide, we've got all these other insurance companies. Healthcare fraud is rampant, and it is because there's so much money in it. You could devote most of your resources to those kinds of crimes. There's state crimes too, but with the FBI and postal inspectors and the IRS criminal division, they have the resources ready to go. Or you could say Columbus is in an epidemic of violence. Let's prosecute felons in possession of firearms. The Columbus police arrest somebody like that multiple times a day. And by the way, in both of these offenses, the federal punishment tends to be much harsher than the state court penalties. So if you pick one of those two, what do you think the racial implications are? White collar Medicare fraud versus felons in possession of firearms. And we have had a push on felons in possession, and they're not all of color. I don't mean to make a statement that broad, but we keep statistics on all of this. It's very easy to see what the effect of it is. So it's not just how people are treated individually, it's how the cases are teed up, it's how they're prioritized. And I think we need to sensitize ourselves a lot more to the implications of the policies we follow in the criminal justice system and make sure that, we're aware that we are tilting things a certain way. And by the way, when you get to individual drugs, it's staggering. We don't do a lot of LSD cases, but there are a fair number nationwide. Those are Caucasians, and they're mostly males. When we get to crack cocaine, they're mostly people of color in the inner city. These days, when we get to fentanyl and heroin, they tend to be spread all over. You've all seen that in your caseload. So there are some things we can do immediately, and then there's some bigger picture things where we have to look at the system and decide, all right, let's not take this stereotype of inner city drug dealer and pretend that doesn't happen in the rest of our community anymore, because we know it does. And make sure that we haven't built in these biases into just who we prosecute and how we prosecute. You remember for years in the federal system, a small amount of crack cocaine would result in a mandatory minimum sentence of 5 years, no matter how small or no matter how young you were, as long as you were an adult over 18. And, there are lots of people that began the federal version of mass incarceration. That law has been changed, thank goodness. But those kinds of laws still abound with mandatory minimums and built-in stereotypes.
I wanted, and I don't know if this is appropriate, but I actually want to say to ask Judge Stroud, in terms of when we're talking about the disproportionate incarceration rates, I just wonder if you could speak a little bit to the juvenile side of that, because I know I've heard you speak about it before and it's always startling to me. And then I know that you guys are doing some good things on that end too, if you wouldn't mind a little bit of time to tell us about that.
Sure. So just briefly in our juvenile court, what we see, because we keep data on all of these things, again, to try to see if we can improve our systems and policies. So as far as who comes before us, we have about 78% of the litigants that come before us that are persons of color, which we know is in no way reflective of the population here in Franklin County. And then when we talk about our juvenile intervention center, as far as who's held there, on any given day, it's going to at least be 90% African-American males. And most times the number is even higher than that, closer to that 95% on any given day. So what we're working to do is to put more programs into place to see how can we help our families before they get that far to where we feel like they could land in our juvenile intervention center. So one, making sure that we're doing more our JDAI initiative, Juvenile Detention Alternatives initiatives, to make sure that we're doing everything that we can so that we're not only holding youth and that we're reserving those holds for only the most serious cases where there is some type of danger to the community or danger to himself or herself when we're deciding who we're going to hold. And then we now have a family stabilization unit that's in place that we're working with the County Department of Job and Family Services, so that hopefully on the overwhelming majority of our cases when they come in, even whether it's an unruly or a misdemeanor case, that we can link our families with services, again, to try to keep them away from the courthouse so that they don't feel the need to come here, have an active case, because we realize the trauma, right, that our youth endure simply by coming into a courtroom. So we're working to do everything that we can to keep as many youth as possible outside of the courtroom, and then also have the data to show that crime has not increased because we're using this juvenile detention alternative initiative. So we're able to balance, obviously, community safety and keeping the community safe and doing what's best for the persons that come in front of us from that standpoint in our juvenile court. So I'm wondering for all of you, we've talked about pretrial. So what about when it comes to sentencing at the end? What's going through your mind, if you could share with the viewers? Are you thinking about things such as mass incarceration, about marginalized communities? What are you thinking about? Obviously balancing the law and what your restrictions and what you need to abide by to make sure that your sentence or disposition for the case is within those constraints. But what else is going through your mind, if you could share with the viewers? What are you thinking about when it comes to sentencing at the end of your case?
I think all of, go ahead.
No,
go ahead.
You go right.
No,
No, Your Honor, you please go right ahead, sir.
I'm through. No, my quick answer was going to be all of the above. You mentioned a number of things that are critically important. And you take all of those things into consideration when you're sentencing an individual. There are some certain crimes that have mandatory sentences that you must impose, depending on the seriousness of the offense, certain sentences you must impose. But things that fall within your discretion, then you take all of those things into consideration and then make the best decision that you can make with respect to how this person will be at the end of this process. Ohio passed laws where the victim has mandatory rights that you must respect and honor. So you have to do that. But in the end, it's up to the judge to make that final decision. I've made some decisions where the victim was really irate, disagreed with it, stated so on the record. But in the end, I made the decision that I felt was the best decision. And then you proceed from there. And realizing that you're not there to please the victim, you're not there to please the defendant necessarily. You're there to please whatever your concept is of justice. And looking at what will happen in the end.
I was just going to say, all that Judge Reece just said there, it's spot on, right on point. When you get to the sentencing phase, you really do consider so many things. One of the things, obviously, that I first want to consider is what in the world drove this individual to the point where he or she is standing before me. And in that respect, I do tend to give defendants quite a bit of time to speak if they so wish, to just give me a little bit of background and a little bit of history about how you found yourself standing before this court. And again, I think there is no substitute, I think, in any courtroom for any judge. There's no substitute for listening, active listening to learn about the individual standing in front of you. I don't know how you can arrive at a just decision without thoroughly listening to the individual in front of you. And it's more really than just looking at that pre-sentence investigation. It's really looking at that individual in front of you and trying to figure out here what drove that individual to this courtroom, and then what would be a just sentence, a fair sentence for this person. And then obviously we do think about the fact that, certainly the minority population, we see them, sentenced to jail time more frequently than we see other races. And we just, all of that certainly comes into play, and it comes into our thinking. And so it really is just that balance, but then also not losing sight of the fact that this case really is about this individual standing in front of me. I really need to hone in and focus on what would be a just result for this individual in this case before this bench.
Could I just jump in real quick? Two things I wanted to say real quick. Number one, and Judge Munson will probably agree with this, I always demanded that the defendant talk with me. And I remember even sometimes when she was appearing in front of me, she was telling her client, don't say anything, don't say anything. But I always insisted that they talk to me because I wanted to hear what they had to say. The other thing I wanted to mention is just because my skin is this tone does not mean I can't be biased. Implicit bias exists. It exists within all of us. And we need to make sure that we understand it's there. If we recognize it, we can do something about it. Thank you.
Yes, that is so critical, making sure that we all recognize our own implicit bias, what that means, and what we bring to the bench when we come. Judge Sargus, were you going to share with us what your thoughts?
Yeah, I don't know if anybody saw the movie The Judge. It's a few years old now. And there was a scene in it where this old judge was on trial for killing somebody, and his son was defending him. His son was kind of a ne'er-do-well who suddenly became a successful lawyer. Imagine that. And in the middle of the movie, he's trying to make his father walk back a statement. He's asking him, why did you sentence this person so lightly? Because this person went out there and killed a young girl. And the dad yelled at him, because he reminded me of you. And that takes us to the word empathy. And that's, by the way, can be a red hot button when it comes to implicit bias. We as judges, I know Judge Munson stressed this in the beginning, I agree with her 100%. There's a shared humanity we have with every defendant in front of us. But you can kill that with implicit bias when we start calling people super predators, as history now, hopefully. But those kinds of words were meant to dehumanize. And so in the end, I agree with what Judge Reece said and what Judge Mingo said. Sentencing is very hard, first of all. And we want to be as inclusive of every factor we can think of. One of those factors is protecting the public. If it's a crime of violence, you don't want to sentence somebody lightly and have them go out and kill somebody else. So that's not my typical case, though. We have the sentencing guidelines to deal with. That's another story for another day, but most of us on the district bench had figured out how to get around those a long time ago. We still squirrel our discretion very, very much. And then there's also the Court of Appeals to worry about. Those aren't what I think about primarily, but they're backstops if things go awry. But I'm somebody, I pitch to defense lawyers all the time that if your client has some issues with mental health, we will pay for a mental health assessment. Let me get the whole picture here. If there are addiction issues, there's normally months in between the original charges and the sentencing. Get some treatment, get some inpatient treatment. We'll be delighted to move a sentencing if a person's at the House of Hope or somewhere like that. Be assertive to make sure I know everything I need to know before I sentence that person. So, and then the final thing in sentencing, we do have a lot of options through the Federal Bureau of Prisons. I can get people drug treatment, mental health assessments, inpatient medical care if they need it. It's not perfect, but there are some good options. And sometimes it's tempting in our jobs, and we've been told by the Supreme Court not to do this. I could add a few months to your sentence and get you better drug treatment sometimes. But that's not supposed to be a legitimate sentencing factor. So we can't say that in the course of sentencing. But long story short, you've got to see the person as a human, as somebody with shared humanity, and you do the best you can to do the sentence that serves all these various interests. The victim, as Judge Reece said, the public, but most importantly, the defendant.
I want to say, and I'm sharing this, and I already shared it with Judge Reece, so I'm not surprising him on this event by saying it to him. But, you know, I haven't been on the bench that long, but I had one of them, it wasn't a sentencing, it was a judicial release hearing, you know, where I was letting somebody out, and not particularly early. He had served 13 of a 15-year sentence and was a model, absolute model incarcerated person. But it was a very serious case, and the victims were injured and, you know, physically and mentally traumatized. And so I had made the decision to set it for hearing, and I really believed that releasing this person was the right thing to do for what he had done, and also to keep him on a kind of a specialized supervision probation plan that I could put in place to guarantee or increase the odds of his successful transition back into society. And during the hearing, well, first I received lots and lots of correspondence, upset that I was even considering it. Then at the hearing, the people participating, some very, very angry people that were in front of me expressing their displeasure. And I was there, and I told this to Judge Reece. When I was sitting there, I was transported back to a time when I was a defense attorney in his courtroom, and he was doing the sentencing in one of my cases, and doing what I thought was right and was the right sentence, and he thought was right. And I watched a blow up in his courtroom at him about what he was doing. And I saw him still sit up there, you know, with the courage of his convictions and do the right thing in that moment. And I was channeling him to the best that I could during this judicial release hearing. And I did what I thought was right. And I still think it's right. And there was, you know, some blowback for that in terms of things that were said here and there to the press or whatever. But I think you have to do what you think is right. And you take all these things into consideration, and then hearkening back to what Judge Mingo said about not clutching the rope too tightly. You know, you're here to do a job. And if that, people criticize that, well, please, at least you want to go to bed at night doing that, knowing that you did the right thing. And Judge Reece was always an example of that. And I actually held on to that part of him when I was doing that judicial release not too long ago. And I will always thank him for having taught me that and given me that fortitude. So.
Can I chime in? First of all, congratulations again, Judge Reece. That doesn't surprise me. It's the kind of person I know you to be.
Absolutely.
But what Judge Munson just said, let me just, I don't know anything about the case and I don't want you to tell me, but somebody served 13 out of 15 years. Let's kind of dissect that for a moment. When that person was originally sentenced to 15 years, it was a fixed term or something close to that. That's what happens in our court. I give you 15 years. There's a little bit of a formula, but I can't change it once you're sentenced. And that's one of the deficiencies in our law. When that judge sentenced a person to 15 years, you don't know 15 years later if they're fighting with guards, if they're helping other inmates do their resumes as they're leaving. They could be the most productive, helpful person, or they could be somebody that guards all hate because they're disruptive, they're doing whatever in a prison that's illegal. So here you are 13 years later, and you do know what the result was of those 13 years. You had that insight that the sentencing judge didn't have. That seems to me to be a great decision. And I wish as a sentencing judge, we had the authority, particularly with people who are very young. Sentence somebody 19 years old to 20 years. 10 years later, they're a different person. And there's nobody in our system that has the ability to say, whoa, this person's really learned his or her lesson. Let's reevaluate the sentence. That used to be the law before 1987 in the federal system, and I think before about 1994 in the state system. But the idea of that kind of discretion post-sentencing has been bled out of our system, and I think that's a mistake.
This has been a wonderful discussion. Judge Reece, were you going to say something?
Yeah, I looked at the time and I noticed it's 2 or 3 minutes and you're getting ready to sum it up. The one thing that I would leave those listening with from my perspective is that this has been going on all week, dealing with re-entry. And here we are as a few judges getting together talking about what our role should be and can be. Hopefully, with all of the things that those listeners have seen this week, they will realize that when you go in front of us judges, be ready to talk about some of those things that you participated in all week so that you give us more options to make sure that you come back productive and you can re-enter society ready to do your part. That was the last thing I wanted to say.
Oh, yes, that was wonderful. And for the viewers, that is our hope. One, that you've been able to see more, what is going through the judge's mind, what the judge's thoughts are on reentry, how we take all of these things into consideration in addition to the law. We are thinking about mass incarceration, the disproportionality that we're facing within our judicial or the criminal justice system at large, as well as our communities, first and foremost, that we all recognize that we are servant leaders here for this specific time to serve those that are coming in front of us, and that we want to do what is best in light of the law, in light of justice, and not just for some, but absolutely justice for all. And that we're doing everything that we can to learn more about the resources, more about special programming and specialty dockets in courts, so that we're not just taking our thoughts on justice as a one size fits all, but really trying to tailor the decisions that we're making to the specific cases. So hopefully you all have benefited from this session and hearing from all of these wonderful judges. Thank you to all of the judges for your transparency, for sharing your thoughts, to be able to give the viewers more of an outlook on what it is that you are considering when these cases come in front of you. So I cannot thank all of you enough for this very insightful discussion and conversation, to Judge Sargus on the federal bench, to Judge Reece, who has been a mentor to so many of us as judges, which is critical. for those of us that consider ourselves newer judges, to be able to have someone to look up to who really does have our best interests in mind and making sure that we're bringing our best selves to this position. Thank you to Judge Mingo over in Municipal Court, as well as Judge Munson on the general bench. Knowing that all of you are on the bench, hopefully is giving the community a greater sense of confidence, and knowing that the judges who are there really do care about their community, are forward thinking, and making sure that we make equitable decisions. So thank you to the coordinators of this discussion for Central Ohio Reentry Week. We thank all of you for being here with us this afternoon, and wish all of you the best.
Thank you.
Take care.
Nice to see
All
everybody.
right, take care,
Thank you.
enjoy.